Okay, we are going to go ahead and get started. Thank you to everyone who is here on behalf of the Columbus Bar Association. This is our second in a series of community conversations on race and the criminal justice system. We are focusing today on just a few parts of that system. So jury selection, sentencing, and specialty dockets. Here to offer their insights are Franklin County Court of Common Pleas Judge McIntosh, as well as Attorney Frederick Benton. Thanks to you both for being here. The format for today's conversation will begin with our guest offering a little bit of background on their experience in these areas. From there, they're going to lead us through a brief overview of the topic to help guide our conversation today. The remaining time that we'll have together will be devoted to your questions, weighing in on the issues that are most important to you. You can submit those questions using the Q&A function at any time, and the questions will be addressed in the order that they make the most sense as we're moving through. As with many of our community conversation topics, these issues can inspire passion, conviction, anger, and even deep pain. And our community conversations are an environment where respect, curiosity, and empathy are not just encouraged, but they are in fact required. Questions or comments that fall short of that requirement will not be addressed. Again, on behalf of the Columbus Bar Association, thank you all for being here, for your openness and your willingness to engage in productive dialogue, and for leaning into one of the pressing issues of our day. Judge McIntosh, let's begin with you.
All right, thank you very much, and thank you to all of those that are here today, and hopefully we will have a beneficial conversation together about the issues that are impacting and affecting all of us right now. I was asked to just provide first just a little background information about who I am, and I guess to some degree also why this topic is something of interest to me. I've been on the Common Pleas bench since 2007. Prior to that, I was the chief prosecutor for the city of Columbus, and I did that for approximately 10 years. And then prior to that, I was with the law firm of Crab Brown Jones, Potts and Schmidt, now Crab Brown James. And part of my practice there was criminal defense work, both in common pleas and the municipal court as well. So for the vast majority of my career, I've been involved in the criminal justice system, which I absolutely have enjoyed during my career. What I've been doing mostly as chief prosecutor and as a judge is trying to get involved in our legal system, and being at least at the table through the Supreme Court primarily in a position to help make some of the changes that our system is looking at going through. So I've had the opportunity to be chair of the Supreme Court Commission on reviewing our grand jury process, vice chair with the Supreme Court and State Bar Association Commission on reviewing the death penalty in Ohio. I'm currently on the Sentencing Commission, where I served on the Sentencing Commission as chief prosecutor, and now I serve as one of the Common Pleas Court judge representatives as well. And as we discuss these topics, I'll kind of explain as well how I think serving on those, how that helps, or at least provides a role in taking a look at many of the issues that we're looking at right now. And then many of you may not be aware, but in 2001, while still in the prosecutor's office, I was asked to serve as special prosecutor in the city of Cincinnati. Some of you may be aware when they had the riots in Cincinnati because a young African-American male, Timothy Thomas, was shot and killed by a Cincinnati police officer, Stephen Roach. And so they asked, they had the case presented to a grand jury, and the grand jury came back with a couple of misdemeanor charges. And they sought to have a prosecutor from out of county Janet Jackson was the city attorney. She asked me if I would accept that responsibility, and I did. And it heightened my understanding and appreciation of how those types of cases have a profound impact on everyone in the community. And why, to some degree, I guess now, it's a difficult issue for prosecutors. You know, when I left when I decided to run for judge, it was interesting. I did screen with the FOP, and I was extremely surprised that the vast majority of our discussion was around why I decided to prosecute a police officer. You know, I saw it as just doing my job, and that it was my responsibility that if someone's charged with an offense and I'm asked to be a prosecutor on the case, like any other case, you evaluate the case and you move forward and do what you think is appropriate. But that was a real big issue that as a prosecutor, I was actually willing to take on a case in which a police officer was prosecuted. And so it was eye-opening to me, because I just assumed that many of them would see this just as my job and not as some sort of personal affront to law enforcement. So I come, at least from that perspective, of at least being a prosecutor that has prosecuted cases against police officers and some of the pushback that I ultimately received. Because as chief prosecutor, I did not receive the endorsement of the FOP. I've not ever received the endorsement of the FOP. And while I did screen with them this past time when I was running unopposed, they decided not to endorse in my case. So that's just a little bit about me, my background. And then after Fred talks, then I'll have an opportunity to get more specific about the topic that we have.
Okay. Good afternoon, everyone. My name is Fred Benton. I am an attorney here in Columbus. I've been practicing now for over 40 years, a graduate of Capital University Law School. I have my own practice here at 98 Hamilton Park. I've been involved in criminal defense when I was in law school, actually, to begin clerking with the Franklin County Public Defender's Office. So I literally cut my teeth there. Ironically enough, when I was considering becoming a lawyer, and I was inspired by individuals like Thurgood Marshall, Spotswood Robertson, James Nabreth, and the like, I never considered practicing criminal law. I had that common misperception that by practicing criminal defense, I would somehow be getting my hands dirty. But once I got a taste of it, and I recognized how important the role is for a criminal defense lawyer, and I recognize how much there is of a need in protecting the rights of citizens who have either been falsely accused or who have been justly accused but are indeed entitled to a fair process in terms of the adjudication of their guilt or innocence. I've seen police work from both sides of the coin. My father was a sergeant in Philadelphia with the Philadelphia Police Department. I was in Philadelphia during the time of the Frank Rizzo being a commissioner. At that time, they had the whole MOVE uprising, and there were a lot of issues associated with police brutality. So this is an issue that I think is certainly relevant for our discussions here today. I'm glad to be a participant in this conversation, and I think that it is at least good that we've been having this type of dialogue. My only hope is that the dialogue will lead to action, the dialogue will lead to change, and the dialogue will lead to a new understanding as to the issues that we're confronting. I've been part of my activities, not only in terms of in the courtroom, is also outside of the courtroom. I'm a member of the Mount Olive Baptist Church, And we've been involved in a number of efforts to try to foster a better understanding between our community and the Columbus Police Department. I've participated in forums. I served as a moderator for forums in which his questions has been raised. We've had former police chief Kim Jacobs at our church, Commander Strasbaugh, who is over the district that involves our church. We've had our young people sit down and talk with police officers on these issues. We had city prosecutors, with Franklin County Public Defender, and the like, because we recognize that it is important that there be an open and honest dialogue from both perspectives as to the issues that we are confronting. I'm currently nominated and I'm serving on the committee to establish the Columbus Review Board. And I'm happy for that appointment, and certainly commend Mayor Ginther and Councilman Shannon Harden for their efforts in that regard. In terms of the issues for which we're addressing, and again, I'll defer to the judge, but there's always a question as to whether or not there is an issue of race within our judicial system. Some will say that it's not, others will say that it is, and then there you have some different opinions somewhere in between. And I'm not saying that to raise the issue means that you have to play, quote unquote, the race card, but I think that we all would do ourselves a disservice to deny what's right there in front of us. And we need to address those issues, not only as they relate to the obvious, but also those subtle practices, policies, and procedures that have an impact upon our community.
Absolutely. Thank you so much to you both for being here to help guide our conversation. As they both alluded to, we're going to give each of them an opportunity to give some brief remarks, but as they are doing so, please feel free to go ahead and submit the questions that you have. Again, we will group them and address them in an order that makes the most sense as they come through, but don't feel like you have to hold back. And again, you can do that using the Q&A function. For those of you who are joining us from your phones, the Q&A function should be right at the top of your screen, right next to the leave button, so don't hit that one accidentally. For those of you who are joining us from a computer, the Q&A function is usually down towards the bottom of your screen, and you just click Q&A and you can submit your questions from there and we'll receive them. So without further ado, Judge McIntosh, we'll go back to you.
Okay, thank you very much. You know, the criminal justice system, at least from the court's perspective, I think is continuing to evolve. I think most participants in the system understand and appreciate the fact that changes need to take place. You know, we can debate, I think, on and off whether there is direct racism taking place. But we cannot debate the fact that in our system, there are a group of folks that are disproportionately represented. And so, you know, we can argue how that happens, but we cannot deny the fact that it is clear that it is. And I don't want to spend a whole lot of time, at least as to my opinion, why, but I do believe that out in the community that there is over-policing in the inner city. And what I mean by that is just the fact that a person would get stopped for a taillight violation in Columbus, which probably would go by unnoticed or ignored in a suburban area. And so because of the fact that they're more inclined to do that, and unfortunately, and Fred can probably agree with this, a large percentage of our gun cases and a large percentage of our drug cases are based upon people that get stopped. They don't have a valid license, or the officers smell weed. They have an opportunity to search the vehicle and they find drugs and guns. Now, when I talk with African-American audiences, particularly young African-American males, I tell them all to get a driver's license first. And when they complain, well, the police are stopping us, I say, yes. An officer that stopped you for a taillight violation is just doing his or her job. Again, we can argue as to whether they should be or not. But if they're doing their job and you're getting stopped and you have drugs and guns in your vehicle, okay, you shouldn't be driving around with drugs and guns. And if you had a valid license, maybe you would just get a ticket for the light and go about your business. But I only say that because I think that's one way that a lot of folks get into our system, at least, is because of that. Now, when I say that the court system, I think, is evolving, and one of the best examples that I can provide, when I started off as a young municipal prosecutor in 1984, prostitution, for example, we didn't think beyond, okay, this person has been charged with prostitution or soliciting. It was usually, would work out a deal, time served, and the person is back out on the street. What got them into the court system, what resources they need to stay off the street corner was something we never even considered. Now that the court system, at least through like the catch court, is starting to figure out that many of these women are victims. And so we're trying to deal with them based upon their needs. That's the same thing with all the other specialty dockets. I'm the drug court judge for our court. One of the things that we have to do as a certified court is make sure that we have a cross section of folks in our court that look like our community. Some of the complaints that have been about specialty courts is that it has not been accessible to people of color as much as other folks in the community. But that's one thing that we have to do, and I would assume any of the certified courts around the state need to make sure that their demographics represent what their community looks like. So I think the criminal justice system is evolving in that way. The other way that I think we're taking a hard look at ourselves is in the realm of sentencing. Again, whether all persons that come before judges are being treated and that the sentences accurately reflect either the seriousness of the offense for which they've been charged or not. Unfortunately, in Ohio, we as judges have a lot of discretion when it comes to imposing most of our sentences. There's some limitations on low-level offenses, but on the vast majority of the offenses, there's a range that we can impose a sentence. Just recently, the Chief Justice has put together a sentencing integrity committee, which I'm on, but unfortunately, COVID hit before we could even get to our first meeting. And so we'll be meeting sometime in September to begin taking a look at sentencing patterns around the state. Because the thing that we need to avoid, obviously, are disproportionate sentences as it relates to people of color in the community. You know, whether people of color similarly situated to others are getting harsher penalties or sentences based upon exactly the same factors that all of us as judges have to take a look at. And Fred may have a better appreciation because obviously, since I've been on the bench, the judge whose sentencing pattern I know the best are my own. And so it's our responsibility and our job to take a look at, I think, individually how we are looking at sentencing. Now, one of the things that we as judges have to acknowledge is that we're all biased. I get involved with new judges. Me and a couple of other judges teach judges on judicial fairness and implicit bias. And most seem to get it. I mean, others don't, but most seem to understand that we can make decisions that disproportionately impact individuals without acting intentionally. It's just, well, I mean, a person of color's in front of me, or in front of a judge, and the judge may not realize that they tend to sentence more harshly. I mean, there's other factors, obviously. We discussed the whole gamut, that includes, are you sentencing more harshly if you know that someone is gay? Are you sentencing more harshly based upon economics and things of that sort? And so at least the system is beginning to understand and appreciate that we have to consider all of that in how we go about sentencing individuals, so that we're not, again, impacting folks disproportionately. As to the other couple of questions that were asked with jury selection, again, it's our responsibility as judges to make sure that persons that are here for jury process, that they are not taken off of a jury panel for a discriminatory reason. And there's case law that lets us know what our responsibility is in that regard. But here's one thing that I've noticed as it relates to at least people of color and jury service. As the administrative judge, one of the things that I do is provide orientation for grand jury. Now, grand jury service is for 2 weeks, and you serve approximately from 8 in the morning until noon. I always, after getting the orientation, say, okay, is there someone that cannot serve? And it always disappoints me that a disproportionate number of people of color are the first ones in line trying to avoid service. And many of the things that they will tell me is, well, Judge, I don't know that I can be fair and impartial. Or, Judge, I don't trust the system. And I want to tell them, well, you're the ones that we need. You're the ones that need to keep and hold us accountable as well. And so it's because of that mistrust that we need to continue to educate the community about what goes on down in the court system. And we want to encourage more people of color to get engaged. Can everyone hear me okay? Okay. And then finally, just in general then about specialty dockets. Specialty dockets, I think, are here to stay, and I think they serve a wonderful purpose in our court system because it allows us to deal directly with the issues that are impacting people. In our drug court here, in the common pleas court, any person that is accepted into the program, if they do everything that we ask them to do, it's going to take them about 1.5 years to successfully complete drug court. And that's without any sanctions, any violations, or things of that sort. But those that actually get through will end up with, usually have jobs, if they have issues with children's services, have regained custody of their children, have a place to live. It amazes me how proud many of them feel when they maintain jobs and are actually able to get bank accounts, which they've never had. So I think the system is trying to actually look at the issues that individuals have and come up with solutions to make them productive in the community. And so the specialty courts, in municipal court, they do have a couple of drug courts, mental health court, veterans court, and the catch court for prostitutes. So again, I think it's a recognition on our system that we have to do more than the option of, well, we'll just give you community control and hope for the best, or we're going to send you to jail or prison. So that's just kind of a general overview from my perspective as to the 3 areas that we're going to be discussing today.
Wonderful. Thank you so much. Fred, we're going to pass the ball over to you for the same.
I just want to kind of touch upon a couple of the things that were said and also addressing the issues that have been outlined. One of the concerns that I have when we have these kinds of discussions is a misperception that sometimes folks take away from these type of discussions, to assume that somehow because we are talking to one another about an issue as important as race, that and our criminal justice system, that somehow we are saying that all judges are bad, all prosecutors are racist, all police officers are racist. That simply is not the case. But the other side of that coin is that you have to be prepared to call a spade a spade. You have to be prepared to examine the issues. And if we stick our head in the sand, then we miss opportunities not only to affect change, but also in my instance, to protect the interests of my clients. Give you an example. A lot of this, both in terms of the charging decisions that are made by law enforcement when they stop someone, by a prosecutor when they decide to indict, and also offer a plea agreement, and even in terms of a judge, all in some fashion dependent or based upon some level of discretion being exercised. And so when you see a pattern of that discretion being exercised in a lot of instances in favor of one group and not in favor of another, or at least if there is that perception that one group is being favored and another group is being disfavored, that creates a problem that we need to address. Nobody's going to, well, I won't say nobody, very rarely you're going to have situations in our process where somebody's going to come out and blatantly engage in racist practices or make a racist statement. But again, you have those circumstances that occur, and if you're afraid to speak up about it, then the problem continues to persist. A couple of examples. One of the most important processes in a criminal trial is that of jury selection. My friend Stephan Thomas and I oftentimes talks about that. And I had a trial one time in which it was a death penalty case. And in those processes, you have a more elaborate questioning of jurors. They fill out questionnaires that are far more detailed than the standard questionnaires that are presented to a jury. And those questions are geared specific to the case that's being tried, and particularly as it relates to their views concerning capital punishment. And then you follow up, of course, with direct questions to the individuals after you've reviewed their application. Well, this one instance, there was an individual who was an executive vice president for one of the major corporations here in Columbus. And one of the questions that was asked on the questionnaire was whether or not their ability to be fair and partial will be impacted by the fact that our client was African American. And he said yes, which not kind of surprised me, shocked me quite honestly, because from the outward appearance, you have an individual who had obviously accomplished certain things in life, who you would think to be of a reasonable degree of intelligence and sophistication. And here was his answer to that question. And when my co-counsel was suggesting, well, maybe I should just leave it alone and then we move on. And that is just not my nature. So when I questioned this individual about why it was that he held such a view, and his answer was simply this, and this was back some time ago. He said, well, when I watch the reaction of African Americans to the verdict of O.J. Simpson, cheering the fact that he was acquitted, that changed my opinion regarding African Americans. And I cannot sit on a trial and promise you that I'll be fair. It made no sense to me, but that was his rationale. Give you a more recent example. Oftentimes during a trial, each side has the opportunity for what are known as peremptory challenges. That means you basically excuse a juror because you have some idea, some thought, some hunch, as it were, that this person will not be qualified. And again, I think, I don't remember the nature of the case, but there was one young lady who was one of the remaining, one of the few Black jurors that we had. And the prosecutor proceeded to excuse her. And that something about it just did not rest well with me. So then when I questioned the prosecutor about that, I raised what was known as a Batson challenge. Then the prosecutor is by law required to give a reason or an explanation as to why it is they made that decision or made that choice, and their reason must be based upon non-discriminatory terms. The only rationale that prosecutor could come up with was that this young lady was wearing white shoes after Labor Day. That clearly told me, and it told the judge immediately, that his reasons was not based upon a non-discriminatory basis. And that prosecutor is still serving today. So those are the kinds of things that you see and that you have to watch out for. And sometimes it's not as obvious, oftentimes it's more subtle. The other concern that I have in these kinds of processes, while the judge indicates that the judge does have discretion with respect to sentencing, and that's true, but the discretion that the judge exercises is oftentimes limited by the scope of the plea agreement. Many of the laws that we are dealing with involve mandatory sentences, which says that before it even reaches to the point where a judge then begins to assess what penalties are to be imposed, certain penalties or certain options are automatically off the table. And so then, again, from a discretionary standpoint, if you have a prosecutor who insists, and I'm not saying it's always wrong, but sometimes it is, upon a plea agreement or an outcome that requires the imposition of a mandatory penalty, that raises a concern, particularly when you see a pattern that will suggest that the reason behind that may be, I'm not saying exclusively, but may be influenced by an individual's background. There was one prosecutor that I know is no longer with the office, well-meaning, I have a great deal of respect for him. But one of his thoughts was, because he viewed it as a tool to eradicate violence within the community, one of his thoughts was, well, if he has an individual that fits a particular profile, which 9 times out of 10 involve young Black men within the community, that his position was that he wanted to get them off the street for a substantial period of time until they're past the age of, I believe it was 35. And his thinking was that if I remove the most productive years of their life by virtue of this plea agreement, that makes them less of a threat to society. But the problem with that rationale is that it ignores that eventually this person is coming back on the street. And then when they do return to the street, what do they have to look forward to, and what will be the opportunities that are there in order for them to address? And the other thing I would say, somewhat in conclusion, one of the things that, and I think the judge would agree with this, I believe that our courts have certainly taken on a more expansive role. But sometimes the roles that the court assumes are really involving matters that should not be before the court. We're dealing with issues that involve the breakdown of families. We're dealing with issues that are the outcome of serious mental health issues, serious drug addictions and the like. And while the court can provide certain avenues or parameters within which those matters can be addressed, they really should be addressed before they even come to the court. And we certainly need more resources, not only in addition to our court system, but outside of our court system to address those kinds of issues. And then finally, when we're talking about, again, the impact of our judicial system, one of the things that I think is particularly troubling and has a significant impact within our community is this whole idea of convictions. There has been a more expansive view taken with respect to expungements, but the problem is that it needs to be expanded even further. You have individuals today who cannot get a job because they had a felony conviction 20 years ago, because they don't meet the qualifications of a first-time offender. Those are the kinds of things that I think that needs to be addressed so that folks can, in fact, have a true second chance at life.
Absolutely. Thank you so much to both of you for those introductory comments. It actually provides for a pretty seamless segue into the first question. So we've talked, or I think most people on the call are at least generally familiar with jury selection, what that process looks like, and sentencing as well. But specialty dockets or specialized dockets are something that may be a little less familiar for those who are viewing. And so with that, for either of you, whoever feels most comfortable going over, if you can give a general overview of what specialty dockets are, when they were introduced to the Franklin County court system, and whether or not you feel like they're currently doing what they were intended to do.
I'll defer to Judge McIntosh.
Well, I'll start off and then you can chime in, Fred, if you have anything else to add. I mean, specialty dockets, I think, started right around the 2000s, because I'm trying to think, I was still in the municipal court when we started the first mental health docket there. And the biggest difference between a specialty docket and a regular docket is the level of interaction that the participants have with the court and the judge and the judge in the court system. So in our drug court program, a person that's in the first phase of the program sees me every single week. Every week I know how well they're doing or how poorly they're doing, so that I can encourage them if they're not doing as well as they need to do, or compliment them if they're doing well. And it has, I think, a significant impact on them. It's interesting. I mean, COVID hit in March, April, when we stopped bringing people down to the courthouse. So March, April, May, the participants in my drug court, we were not seeing them in person. They were not being required to provide urine screens during that time. June, we were able to get them back in court on a limited basis, but it hurt them bad. And many of them complained that it was a struggle because they missed the routine of coming to court. They missed the structure that was being provided to them to help them in their recovery. Many of them will know in any specialty docket that they are engaged with, that they need additional structure, that they need the additional encouragement and someone to some degree, particularly early on, telling them what they need to do each and every week. So the biggest difference, a person that I put on probation or community control today on my regular docket, I may never see again, and it's up to the probation department exclusively to work with them. But on the specialty docket, in the first phase, like I indicated, it's every week that I am engaged with them, along with a team that we have of providers from the community. We work with Maryhaven, we work with Southeast, we work with Alvis, Community for New Direction, Ohio Guidestone. All of them are part of our team, so that when we're sitting down looking at an individual, we're trying to figure out what's going to give this person the best chance of success in their recovery. And so a person for Guidestone may say, you know what, it's probably better that this person get engaged with the Columbus Health Department, because what the Columbus Health Department offers them is better than what we can. So that's the biggest difference. And for instance, with the Veterans Court and Municipal Court, you have a bunch of folks that have a similar life experience, and it helps them to be able to understand what each one of them are going through and offer support individually. and collectively to those going through the program. So that's the reason why I think specialty dockets work, because we have much more opportunities to work with people. And generally speaking, the vast majority of them have reached a point in their life. And make it clear, the drug court that we have here in the Franklin County Common Pleas Court are for people that have been through the system multiple times, people that have been to prison multiple times. It's very rare that we get someone and this is their first drug conviction. What we're looking for are the people that have tried and tried and tried and have just not been able to be successful. And that rather than prison being the option for them, let's try to an intensive supervision program to see if that's what helps. And for many of them, they have reached a point in their life where they're just tired of the lifestyle and they're willing to put in the work.
Excellent. And so it does function then as a bit of a diversion program then away
Correct.
from, okay, thank you so much. Fred, did you have anything that you'd like to add?
No, the judge said it all. Well said.
Excellent, excellent. Okay, moving on to the next question. In our introductory remarks, we did hear a little bit about the potential for a statewide sentencing database. Can either of you talk a little bit about sort of arguments that you heard on either side for the need for a sentencing database, or why people are arguing that a sentencing database could in fact be damaging in the way that it would be used for people who are in court?
You want to start, Fred? Okay. As I indicated to you, I work with the Ohio Sentencing Commission, and one of the things that we have done is put together, or put a draft together, we haven't rolled it out yet, a uniform sentencing entry. So it's the entry that all of us as judges file once a case is over. And one of the reasons that we want to encourage as many of the judges around the state to use this uniform sentencing entry is so that we can capture data, so that we can make hopefully apples to apples comparisons as it relates to how sentencing patterns occur within either individual communities or throughout the state. Now, obviously, it's all about how the data is used and the data that we're collecting, and making sure that it's being utilized for the appropriate reason and for the appropriate purpose. Let me just interject something here real quick before I forget about it. You know, the one way, the main way that we can make real, legitimate, and significant change in our criminal justice system is folks voting in legislators that are willing to take a look at the system realistically. When I started in 1984, the criminal code was one book. The criminal code is now 5 volumes. And kind of to what Fred mentioned earlier, a lot of that are offenses that never were criminal offenses before, that the legislature has now criminalized behavior. And then adding a significant number of mandatory sentences in our system as well. And the reason why I say this is so important, this was, I think maybe the early 2000s, early to mid 2000s. We were having a meeting with the Sentencing Commission, and it was about enhancing penalties for sex offenders. And it was one of the few times that everyone on the commission was in agreement that the worst of the worst were the ones being punished, and that the information that, or the statutes that were on the books were accomplishing what they should accomplish. So prosecutors on the commission, defense attorneys on the commission, county commissioners, law enforcement, were all in agreement that there was no need to change what we had on the books. And the representative for one of the legislators said, thank you very much. We appreciate your input, but we're going to go ahead and enhance the penalties anyway. And so it's interesting that even when those that are working in the system recognize that something's not needed or necessary, the politics that gets involved in these situations and these decisions prevent some changes from taking place. And so same thing with the looking at the death penalty in Ohio. Again, some of the recommendations we made, again, were to ensure that just the worst of the worst would be those at least subject to the death penalty, since our charge was not to remove the death penalty from Ohio, but in looking at it. And one of the things that was recommended, and Justice Stratton was working hard on this issue, was ensuring people with mental health issues were not subject to the death penalty. And that was not able to get passed through the legislature as well. And so that's why it's important that even though we in the system can make recommendations and have made recommendations that we believe could help the system, it's only once it gets over to the legislature that any real change can take place in some of the things that are currently on the books. I don't know if you want to add anything to that, Fred.
No, I agree with you. And oftentimes what you'll find is legislation is proposed during a political season to demonstrate that a legislature is tough on crime. You'll have legislation that is proposed as a reaction to a particular case. As one judge was fond of saying, if you have a law that bears the name of an individual, oftentimes that's the product of a bad process, and it's not one that's carefully thought through in terms of all of its ramifications. You also have, I believe at this point in time, less lawyers who are involved in the legislative process. And I think that also contributes to that outcome as well. Again, this is a situation where certainly there's a thought in terms of responding to a problem, which I get, but I think you have to have a full understanding of the scope of the problem and the impact that the proposed solution has, because sometimes the impact might be worse than the problem that you were facing.
Absolutely. Thanks to you both for those responses. We're going to pivot a little bit and talk a little bit more in depth about jury selection. Fred, this is for you first here. As a defense attorney, what have you found most difficult as it relates to jury selection, and particularly jury selection and diversity? Having the opportunity to make your panel diverse, does that have an impact on your case, or do you believe it has an impact on your case? Why or why not?
Well, jury selection is more of an art than it is a science. And certainly the initial reaction will be that you would like to have as many people of color as possible. But as I oftentimes tell my clients, you're not going to have jurors coming in from your neighborhood. They're coming from Bexley, Upper Arlington, Worthington, and the like. But by the same token, just because you have a prospective juror who's a person of color doesn't necessarily mean they're going to vote in your favor. So there are a lot of assumptions, and you have to certainly work through those assumptions. But I think as a general rule, I like to see a fair cross-section of the community as part of the prospective panel. The problem that you face, part of which is that, well, Judge McIntosh indicated, you have a lot of folks from the community who choose or desire to opt out of the process. Some because of their own personal views, but also it represents a particular economic hardship to them, and they don't have the flexibility that perhaps maybe others might have in terms of a jury service. The other thing that inevitably that I find curious and as well as troubling, you bring up a pool of jurors, 30, 35, 40 jurors. The prospective jurors who represent people of color are most often at the tail end of that list. So before you even have an opportunity to get to them, you have to go through a series of changes that may or may not make that person available to you. So again, it happens. So oftentimes what you have to do is you have to work with what you have. And so if I can't get the desired cross-section, I certainly place an even greater emphasis in trying to educate the panel that I do have as to the issues that we're facing.
Excellent, thank you. Judge, is there anything that you'd like to add before we move on?
No, I think Fred was spot on.
All right, wonderful. Okay, so this conversation is happening as part of a three-part series that is looking at race in the criminal justice system. And so while we've talked about that sort of in an indirect way, I want to be a little bit more specific about that. And so in each of your experiences, have you found that there have been marked differences, particularly as it relates to sentencing by racial category when defendants are convicted of similar crimes? If you have seen that, what have the courts or the legal community, what have you seen them already do to try to address any of those actual or perceived disparities?
Well, from my perspective, there has been issues in which you've questioned the outcome of not so much the sentencing, although that certainly is part of it, but it's the prosecutorial decisions that were made that frame the basis upon which the sentence is to be imposed. So if I have a client who is a person of color and the prosecutor makes an offer that requires a mandatory sentence, but out of the same case involving a co-defendant who perhaps is not a person of color, or maybe not even in the same case, but of a different case, but a similar set of circumstances, and they're given the opportunity for a non-mandatory sentence, community control sanction, or a number of other options, that becomes problematic. So have I witnessed it? I have. In terms of how I address that with respect to an individual judge, I can't go and say, well, judge, because of this, my client being sentenced because he's Black. But I do say, well, judge, there are some things you need to take into consideration that are not part of the analysis up until this point. And so you have to be creative in terms of how you respond to it and deal with it accordingly.
Yeah, I think Fred makes an excellent point, and he made part of the point earlier. Sometimes the decisions that are made as to the plea agreement limit what we as judges can do. I don't know if Fred has had the experience where judges question a prosecutor about the plea that they put on the table as to whether or not it was done or could be perceived at least that it was done for a discriminatory reason or purpose. That's hard to be able to confront anyone, any prosecutor, with respect to the plea offer that's in front of us. So it goes back to kind of where I started, that we know, again, that the system is disproportionately impacting a certain community. And we really, again, as a court system, and one of the ways that we can, is really getting into the weeds as it relates to sentencing patterns throughout the state, to see, even if we cannot pinpoint that someone is purposely sentencing a person harsher because of their race or other discriminatory reasons, we can begin to at least recognize the pattern so that we can hopefully then begin to do things to change how our current system is. But the question that you ask, in a lot of ways, is the question that needs to be answered about our system, because we can look at the impact, but it's hard to be able to say, oh, okay, that judge, that prosecutor, in all situations is either sentencing individuals unfairly because of their race, or that prosecutor is not offering people of color the same deal that they would offer someone that was not. And I think that is the question that we as a system are going to need to be able to figure out and answer. Because we know what the result is. We need to be able to show people how we've gotten to where we're at.
Absolutely. Thank you both for those responses. One of the things that people do point to that happens actually before you get into the courtroom are things like broken window policing, over policing generally, but also vagrancy laws because of their the impact that they have in creating a first offense or creating multiple offenses so that someone does end up with sort of a rap sheet, but would consider closely a rap sheet for loitering, for broken taillights, etc. Can either of you give examples of people who have either been before you or that you've represented that have been impacted by either the broken window policing type of practice or vagrancy laws where it did have an impact on their sentencing?
I'm not so sure that I understand the question completely, but what oftentimes happens, and Judge McIntosh had discussed this earlier, is that officers will rely upon very minor offenses because they believe that they have a bigger fish to catch. For example, if you ride down the street, you stop at an intersection, and your vehicle encroaches upon that stop bar, that gives them a basis to stop you. I wasn't even aware there was a stop bar until I ran across my first case dealing with that issue. You have a situation where somebody is making a turn and the officer says, well, they didn't turn, activate the turn signal in a timely fashion or failed to activate it at all. You have circumstances in which that I'm aware of where officers seen someone that they're familiar with due to prior contact, and they'll pull them over just to find out what's going on. So those kinds of things do happen. And again, that comes back to the discretion. There's a recent presentation which Matt Barnes on NBC4 talked about driving and backsliding. He was 1 mile over the speed limit. You have those kinds of experiences that are oftentimes the touchstone that allows for a more broader investigation and additional charges being filed. As a defense lawyer, we challenge those stops as being pretextual, but the problem is that the Supreme Court, the United States Supreme Court, even, as well as the Ohio Supreme Court, has said that pretextual stops are perfectly legitimate. But that's the reality that we have to confront. I'm not sure I answered the question, but that's my response.
And you know, when I was chief prosecutor, since most of the offenses, the offenses that we dealt with were misdemeanors, we would tend to see many of those types of cases, and would, as best we could, try to discourage. Stopping someone because and I want to say, was it either the light on their bicycle or something along those lines. And the person was not doing anything inappropriate, but it may have been that the officer was using that in hopes of trying to find out if the person had drugs or guns or something else on them. Because they stopped them for that, they then had to cite them for that. Now, something like that, I think most of the time we ended up dismissing. But it is not unusual, and was not unusual to see those types of cases coming through, where folks were getting stopped for what we all would consider insignificant offenses, and it would the type of thing where even if the officer truly believed the person had done something wrong, having a conversation with them about it and letting them go would not have been inappropriate.
All right, thank you. I just want to put out a quick reminder to the audience that you can submit your questions using the Q&A feature. The chat feature for the audience is not enabled, so if you're trying to submit that way, it will not work, right? Go ahead and use the Q&A feature, which again, if you're listening in on a phone, is up at the top of your phone by the leave button. And then if you're listening from a desktop computer, it should be at the bottom of your screen, okay? With that, as we move along, are either you aware of any other specialty dockets that are being contemplated? And if not, do you think that there should be?
I don't know if there's any new type of specialty dockets that are being contemplated. Because I think, I mean, if you look statewide, it runs the gambit. I mean, because I know there are some courts that have like domestic violence courts as well. So it's not just limited to substance issues, mental health issues. It's looking at trying to deal with issues more holistically. So I'm not aware of any new types of specialty dockets that someone may be looking at. But there are many more than what I've named to cover a wide variety of issues that come into our system. You know, and at some level, I agree with what Fred said. You know, more resources need to be devoted in the community so that many of these people don't even make their way into the criminal justice system. So that they can hopefully get some of the needs met in the community, whether those are mental health, substance abuse, or otherwise. And so hopefully one of the things that will come out of everything that's going on now is a better appreciation for diverting more resources in the community. One of the most surprising things, I guess, when I got on the bench was the lack of life skills that so many of the people that come in front of me have. You know, they could get a job, but they can't keep a job, because to keep a job means I have to show up to work every day on time and work. They don't know how to actually, you know, like go to the park with their child. I mean, what is that? They just basic life skills that many of us take for granted. And at least it's good that the court system is trying to take a look at that. But I mean, these are the types of things that we need to figure out. And with a lot of them, school, absolutely, education, education, education is where we need to devote a fair amount of resources to figure out ways to keep many of these individuals in school, because they've begun to set themselves up for failure immediately because of the lack of education and some of the social skills that they can pick up while in school as well.
Okay, thank you. Fred, anything you'd like to add?
No, I think you just said it all.
All right.
And let me, you know, it's interesting because I knew I was going to do this today. And I had a case, it might have been the last case that I dealt with this morning that before I got on. It was a young man, he was 19 years old. He was stopped by law enforcement because he had a gun on him, and he should not have. But what was interesting, as explained to me by the defense attorney, and his mother was in court. He was an African-American male. His mother is white. And as they explained to me, when the police went by, he was the only person of color in the group. He was with other friends and family members, all that Caucasian. He was the only one that was identified by law enforcement and approached. And the mother, at least through the attorney, she didn't want to speak on her own, was upset by that her son of color was stopped and no one else questioned, and no one else was out of the group. And so it's, again, important to continue having these types of discussions. I mean, having a son, an African-American son, I'm sure she has a greater appreciation that he's always going to be in a situation where he needs to be careful about how he approaches and does things. But I think more people in the larger community need to understand the experience that she had in that situation that I just described, that what happened there is not unusual to what occurs within our community and around the country every day.
Excellent. Thank you for that. Going back to looking at specialty dockets, I have a question about how does one, I know you mentioned before that the one that you work with directly, these are generally speaking going to be people who have been in the system before, but what is that selection process like? Does it require a recommendation in the same way, a recommendation, excuse me, from a prosecutor in the same way that a plea deal might be limited? Are the people who can participate in that program also limited by sort of the selection of the prosecutor, or is there a different process for identifying people who would work well for that program?
Well, in our program, there are certain types of offenses where I guess where the prosecutor would probably have some objection to that we cannot take. So we don't take offenses of violence, for example. But we kind of take a little bit of everything, and we don't take first degree and second degree felonies either. But everything else is open. And at least the time that I've been doing our drug court, I've never had a prosecutor object to someone that was being recommended for our court. And it's the persons recommended have to agree to do the drug court. And they have to agree because I have a large amount of discretion in dealing with them. Generally speaking, if someone is non-compliant with their supervision, you bring them back to court for a revocation hearing, and the defense attorney has an opportunity to argue on behalf of their client. One of the things that I can do, well, one of the things that I do, if a person is non-compliant, non-compliance could be that they're providing positive urine screens. I can immediately impose a sanction, and usually the sanction is a 3-day jail sentence. We don't bring the prosecutor in, we don't bring the defense attorney in. It's by their agreement to participate in this drug court that they understand that that's something that can be imposed. And so it's because of the level of discretion that I have, we spend a lot of time letting people know exactly what they're getting into. And some people have absolutely no interest, and that's fine. But after sort of explaining all of that to them, it's surprising. Again, like I said, there are just a number of folks that are tired living the lifestyle that they've lived, and they're ready because they don't want to go back to prison. They don't want to continue living the lifestyle that they're living. Now, our court is different because there are drug courts that take first offenders. I mean, a municipal court will take someone that this is their first drug offense and go through a process of treatment and things of that sort as well. Ours is just a little bit different because we want to try to see if we can get to the people that have tried everything else and nothing has worked for them. Hopefully that answers the question.
Yes, thank you. Fred, coming over to you, when it comes to sentencing, right? Obviously, you don't have a direct hand in sentencing per se, but what sort of barriers have you experienced? I know before there was sort of a nod to prosecutors and plea agreements feeling a bit limiting that way. But for you as a defense attorney, what impediments have you found and what you feel is getting fair sentencing for your clients?
Well, before I answer that, I also want to piggyback on the comment that Judge McIntosh made.
Sure.
In addition to specialty courts, the Franklin County Prosecutor's Office also runs a diversion program that allows the person basically to engage in the probationary practices prior to, at the beginning, and then if they're successful, then the charges are dismissed against them. And there's also intervention in lieu of conviction as well. And you have to have someone who is an attorney certainly knowledgeable of these options so that they can make the recommendation on behalf of the client. But in response to your question, sentencing is always interesting. Some are rather routine. In fact, I would probably say most are rather routine. It's not necessarily predicated upon the offense itself, although that drives a large part of that. Is more often a matter of factors relating to the individuals themselves. What I like to see at a sentencing to make sure that my client is adequately represented is that there be an appropriate compilation of data relating to their background. So you would normally have a pre-sentence investigation report. I will prepare a sentencing memorandum, which is my own version of a pre-sentence report. If they've been engaged in any kind of medical or mental health issues that would have an impact or relevance, I include that. Letters of support from family, or even having family and friends come down to the courtroom in support of them. But not all clients have those resources. Not all clients have family members who are willing to come down and stand with them or write a letter on their behalf. Sometimes you have clients, unfortunately, who make it even more difficult than it needs to be as far as their own sentencing is concerned because of how they either responded to the probation officer when the pre-sentence report was prepared or because of additional difficulties that they get into while their case is still pending. So like I said, each case is unique, but the idea certainly is to try to get the best outcome for your clients. And I would tell you this, that's probably the time in which a defense lawyer is most creative because you literally have to make bricks without hay. You have to pull a rabbit out of the hat and you have neither a hat nor a rabbit. So you really have to look at something that would suggest some level of redemption on behalf of your client, some level of promise. And you certainly have to be candid not only with the court, but you also have to be candid with the client in terms of what they need to do in order to make this successful.
Absolutely.
Yeah.
Thank you. Go ahead, Judge.
Can I add, when sentencing takes place, we as judges have the opportunity to obtain a lot of information if we choose to do so. Fred mentioned that the pre-sentence investigation, and sometimes defense attorneys will provide sentencing memorandum. One of the things that we try to impart upon new judges when we do new judges training on procedural fairness is to slow down because implicit bias kicks in when we just make quick decisions, not realizing that our mind is looking at a person in front of us and making certain assumptions about that person without really getting to know them individually. Yes, I mean, we deal with a lot of defendants and it is tough sometimes to deal with all of them individually, but that's what we're supposed to do. And one of the ways that we can deal with that individual that's in front of us right now is by slowing down. Mr. Benton, Fred has done a lot of sentencing in my courtroom, and I will let him talk for as long as he wants to help me understand who his client is and why either the sentence that I may be considering is not appropriate for this person, or understanding that there's going to be some significant sanction, but maybe I should not sanction as high as maybe I'm thinking or have suggested. The only way that we can do as good a job as we can in trying to make the best decision that we can as judges is slowing down. And it never should be, okay, let's get this case and let's push this case through as quickly as possible because I know I got 2 or 3 more right behind this one. And so let me sentence this person so I can get them out of here so that I can deal with the next one, get them out of here. That should not be the case at all. And so we should be listening to all the information. We have an obligation as judges to listen to victim impact information, but also whatever information on the defense side. And so it's important that we not allow our own implicit biases to make the decision for us, that we slow down and listen.
Thank you. Fred, anything to add before we move on?
No, I think certainly what the judge said is correct. I will remind him the next time that he's going to allow me to speak it for as long as I want. but again, I mean, you're dealing with a very important process, particularly at that juncture, and you literally have someone whose life is in your hands, or at least the impact upon their life is within your hands. And it has to be taken seriously, and it certainly has to be approached in an appropriate manner. Because if it's structured correctly and you have the commitment on behalf of the client to follow through with what's recommended, those are the cases where you have your greatest success.
Absolutely. Thank you. The overarching title for this series is What's in a System? And that is a nod to the fact that we're looking at the criminal justice system, but it's also a nod to the fact that systemic racism, systemic bias does exist in each one of the systems that are used in the criminal justice system. And these three are part of that. And so of the three, which do you think is most open to systemic bias creeping in, and why? Whoever would like to start.
I don't know that I could say across the board. I think it varies at different times, depending upon the case, dependent largely upon the participants in that case. So sometimes you might have an issue with respect to a voir dire process. Another time you might have an issue with respect to sentencing. I guess if I were to venture some sort of analysis, it would probably be in the area that I'm most sensitive to is in the area of jury selection. Because again, you're having 35, 45 people come into the courtroom who don't check their biases or attitudes or their experiences at the door. They come into the courtroom with them. So you have to be able to, in a relatively concise period of time, assess who these individuals are. Nobody's going to come out and just say, and although it's happened, no one's going to come out and say, I'm biased. I have a particular racist view or antisocial view as to something. You have to ferret that out. And oftentimes what I tend to do is to try to at least get that individual to admit their own biases and concede that perhaps maybe this is not the case where they should be serving as a juror. So I would summarize by saying this: it can happen at any level, at any process within our judicial system. I'm not saying that it's there all the time, but I do think that there's a duty to keep an eye and your eyes and ears open to watch out for those kinds of potential and be prepared to address them when they occur.
Absolutely. Thank you, Fred. Judge?
I would say sentencing. That there's so many factors that come into play when sentencing takes place. And kind of to my earlier point, it's important for us to concentrate on the person that's in front of us. We cannot, let's say this is the, I'll just take it. This is the third, fourth, or fifth weapons under disability case that I've had this week, and treat this fifth one like the first one. They're all the same. These defendants are all the same. We need to, again, do what we can. And I'm sure that I've had situations or times when my mind was somewhere else, that I did not give the defense attorney or the defendant the attention that they absolutely required in the case. But because there are so many of us as judges with so many different attributes that we all bring to the bench, I think it's the one area that we need to be the most careful, just because the decisions we make have such a significant impact on the victim, the defendant, victim's family, defendant's family, particularly in the more serious cases.
Absolutely.
If I could add to that, when the judge made a comment earlier about pausing, taking your time, I think that's very important, and I think it's very important not just for judges. I think all of us run the risk of our own biases and prejudice, maybe not necessarily based upon race or any other stereotypes, but when you see such the volume of cases that you see and that you deal with, there's sometimes the tendency to fall into a pattern of assumptions being made. That here's another drug case, here's another person who hasn't done what they're supposed to do, here's another person who's not paying child support or whatever the circumstances might be. And there may be a lot of commonality across the cases with respect to an individual's background, the inability to maintain a job, addiction, not finishing their education, being raised in less than ideal social economic backgrounds. But notwithstanding what might be a pattern, these are still individuals, and we have to respond to them accordingly.
Absolutely. Thank you. This moment that we're in as a society seems to be a bit unique, at least as compared to the times that preceded it. And so in this moment, in light of the discussion that we've been having, what do you feel is the bar's responsibility more generally? We do seem to have an ear towards issues that maybe in the past we've had a deaf ear to. And so what do you view as the bar's responsibility in this moment, particularly as it relates to these issues? Judge, we'll start with you.
Well, I think the Bar Association needs to do exactly what it's doing right now. It's one, having these conversations. And I think the bar needs to continue to look at, what is the legal community trying to do to improve and kind of fit in where you think your opinions are necessary. Just like I said before, served on task forces, made recommendations to the legislature, and nothing happens. Maybe, the Bar Association speaking on behalf of something, if obviously the bar agrees with what those recommendations are, maybe that voice may carry more under those situations and circumstances just because of the membership of the bar or the bar being seen as more neutral. So I think the bar needs to be active in finding out, okay, what is the court system doing? What is the court system attempting to do? Or in talking with your membership, finding out where they see issues or concerns in the system so that they can begin making recommendations, because there could be things that we don't even recognize from day to day. That we could change, or that we need to change, or that we need to look at differently. So it's keeping your membership engaged in this, because we know there's not a one single answer to resolve this, and we understand that this is something that is going to take some time, but we need to keep working and engaging on it every day. And the Bar system don't just kind of go back to business as usual, that you're keeping an eye on us and telling us, okay, what is the court system doing about this, the issue of systemic racism? Are the courts really looking at this issue or these issues, and is the court open to making changes? I think that's a tremendous voice that the Bar Association can have.
Thank you, Judge. And Fred, same question to you. And also keeping in mind, again, we are an entity, and certainly there's some power behind that entity, but we are also an entity that is made up of all of its members. So what responsibility do you think that we have, either as the collective entity or as individuals that make up that entity?
There's a verse in the Bible that says, to whom much is given, much is required. We are trained as advocates. We hold a unique position in society that's conferred upon us by virtue of the fact that we are licensed as lawyers. We have the education and training as lawyers. I'm very frustrated oftentimes when there are issues that I think that either individually or more, but particularly collectively, our organization should be speaking out on, and we hide behind the fact that, well, we don't have a policy statement for that, or we have to have it studied by a committee. I mean, you can study something to death. There should not have been any hesitation on anyone's behalf to speak about the murder of George Floyd. There should not be any hesitation about speaking about the issues with respect to Breonna Taylor. When we find ourselves hamstrung by procedural or organizational guidelines, then I think that defeats one of the principal purposes of Bar Association. I'm not just saying CBA, I'm saying any bar association. We are there to speak out and to be advocates to our community. And right is right and wrong is wrong. It doesn't require study, it doesn't require a committee. We know what's out there, and I think that we have an obligation to speak to it.
Absolutely. Thank you to you both for your responses. We are in the final moments. So before we do completely wrap up, if there are any final thoughts that you'd like to share with the group before we go, you have that opportunity now.
I think that I'm certainly thankful to the Columbus Bar Association for this opportunity. This is part of an ongoing dialogue that's taking place within our community. And I think that it is an important dialogue. My hope, my prayer is that this continues to be sustained and that it does in fact result in an outcome beyond just us talking to one another, although that is an important step.
Yeah, well, likewise, I'd just like to thank the Bar Association, and I would hope that the Bar Association will continue the conversation. And I agree with Fred, hopefully there's some action, but what we shouldn't think is that, okay, we'll do this because the issue is hot now, and then we'll move on to something else. I mean, these are the types of conversations that just need to continue because it's the only way, one, to educate people, and two, hopefully begin to make significant change.
Absolutely. Thank you both so much for joining us. Thank you also to all of our viewers. I do want to sort of wave the flag. We will be having an additional community conversation moving on to other parts of the system. This will conclude the What's in the System series, and our next and final conversation will take place on September 10th from 12 to 1:30, also here on Zoom, and we'll be looking at parole, probation, and becoming productive. Again, thank you so much for joining us, and we hope to see you again on September 10th. Have a great day.